Just a follow-up on that. ADR is a tool. It's one tool for cost control and dispute resolution. Obviously, it doesn't work in every case, and it doesn't work well. The procedures in one kind may not work well in another kind. How do you go about at least divining the core of what your ADR philosophy, your ADR practice is going to be? Do you identify some most common kinds of claims? Do you identify the claims that are the hardest to resolve and say, you know, we're really going to go at that? Do you identify the ones that are most likely to produce some large award and therefore will have sort of most bang for the buck? Is it some combination of all those things? How do you go about designing one of these systems?
Okay, for our personal injury cases, except for the very small ones that we try to resolve ourselves, I try to get everything into a mediation as soon as reasonably possible, as soon as I've gotten the information that I feel I need to put a value on the case.
With a standard set of rules, particular organization?
You know, I usually let the plaintiffs decide. If it's somebody that the plaintiff is comfortable with, that dramatically increases the likelihood that you'll be able to resolve the case.
Okay.
For commercial matters, it's a little tougher, and I've actually found that the greatest resistance I experience to mediating those is our business people.
Because?
Because they think that if it's settlable, they can do it themselves. Which
So
is not
it
always the
sort
case.
of an education function to try to convince them that this can help?
Yes.
Yeah, I'm not sure there's a given selection process because each case stands on its own. Each case comes in a little differently. And I just think with the amount of experience in this room and on this panel, you just kind of know. And then that's not really good enough because then you got to, you know, look at some of the other issues that are driving value resolution or where you want to end up. So I don't think it's formulaic to decide that this particular case I'm always going to mediate. Maybe, you know, if it's the 10,000th of asbestos case, you know how to do that. You got a matrix built around it. But other than that, I think each case is on its own. But what we're finding out, even on our severity cases, is that at some point, I think we've all been there, the mediator says, you know, plaintiff wants to talk to you or plaintiff's counsel wants to talk to you directly, or we go out in the hallway and we have that direct conversation. So if that's happening more and more, then is there truly a benefit to that ADR behind the perceived neutral setting, or is it just our reluctance, even on the more severe cases, to sit down with opposing counsel and have those difficult conversations and listen directly to the plaintiff themselves? Because you're right, they all have a story to tell and they want to tell it. So what we're finding is it's not our first option on a bad case to go to mediation. It doesn't say there's nothing wrong with that approach. We're trying to go at it a little differently to see maybe we can get the same result just using the quality of counsel that we've employed.
And just on a percentage basis, would you say outside counsel tend to be in favor of an ADR process or opposed to it or neutral? What kind of advice do you get?
I think it's the rare case where they say, this one we've got to mediate. You know, I think a lot of them, you know, because you hire the lawyer and you hire the lawyer for a particular reason, skill set, you know, place in the community, but taking advantage of all those things, because we all think we hire the best lawyer in the room, right? I mean, that's the way it works, or we think we're the best lawyer in the room. So why not take advantage of that, you know, inherent skill set, because that kind of comes with the price, and go take advantage of it. What's the worst thing that's going to happen? It won't settle and you go to a mediation anyways? So we're trying that, and, you know, hopefully we can come back next year and put some, you know, figures around that to say, here's what we found as an insurance company with specialty lines of business that has a mixed bag of, you know, trucking all the way to products cases, and this is what we found out in taking this approach.
On the other hand, the best lawyer to work that case up and maybe get it ready for trial may not be the best negotiator.
Agreed.
Yeah, we had a little bit of
That's what you're there for, though.
We had a little bit of discussion about that earlier, where somebody was mentioning the idea of having, you know, twin tracks. You got the trial team and you got the settlement team. Go ahead, Kim.
Okay. Well, we don't have a hard and fast rule In fact, most of our cases settled through informal negotiations. We try to open that dialogue at the earliest opportunity. We see through the life of the claim, we're constantly looking at, do we have enough to evaluate this case? And if so, can we figure out where the other side wants to bring it in? Are there any differences between us? When we whittle it down and figure out what the differences are and realize that there's a need for an independent party, that's when we switch to mediation mode and start that process. It's not always the first go-to thing, but we feel like at that point, we've had enough dialogue to know the cases that are going to settle informally and the ones that need something else.